Good afternoon, everyone, and welcome to this webinar. I'm Aparna Ravi, and I have my colleague Sharanya Kundu here with me.
Hello.
Today's topic, as you all know, is the Insolvency and Bankruptcy Code, to which there's been a large number of amendments in a relatively short span of time since the code came into effect about 2.5 years ago. And some of these amendments have been based on recommendations of the Insolvency Law Committee. In other cases, they've been a reaction to judicial pronouncements, as well as implementation challenges that have been seen with how the resolution process has been conducted on the ground. Today, we are going to talk about the most recent amendments to the IBC itself, which is the IBC Amendment Act 2019, which was notified in last week on October 16th, in fact, and August 16th. And we will also talk about another set of amendments to the liquidation regulations. The liquidation process itself hasn't got as much attention as it should. Most of the focus has been on the corporate insolvency resolution process, but there have been important amendments to the liquidation regulations, which I think we should consider as well, considering that a number of the CIRPs do end in liquidation. So without further ado, I will start going. We'll discuss each of the amendments and also give you some background in terms of where these amendments are coming from, the problems that they are intended to solve. And at the end of this, we will leave some time for questions. So if you do have any questions, we will leave at least 10 minutes at the end for you to ask questions, and you can also raise your hand and type in the question as provided. So in terms of the Insolvency and Bankruptcy Code Amendment Act 2019, there were about 8 specific amendments that were made to the code, and we've tried to categorize them in certain buckets. And all of them are a response to issues that have been seen on the ground with the implementation of the code. So one such bucket of issues relates to delays in the process. The code was intended and has always placed a lot of emphasis on timelines. It was intended to be a time-bound process for completion of resolution. But in practice, of course, we've seen that a lot of timelines have slipped for a number of different reasons. So some of these amendments are intended to address this and try to bring the code back on track in terms of adhering to timelines, if not adhering to timelines exactly, at least in the broad sense, not veering too far away from the expected timelines. The second set of amendments, which are, I think, the most significant in this set of amendments, relates to the Committee of Creditors, their functioning and decision-making process, as well as how they are to vote. And related to this, particularly important, is how distributions under resolution plans are to be dealt with. And the final set of amendments here relate to resolution plans themselves and are more clarificatory in nature. So with this introduction, I'll turn it over to Sharanya to talk about the amendments made through the Insolvency and Bankruptcy Code Amendment Act that address delays in the resolution process.
Thank you, Aparna. So the first set of amendments that has been carried out in 2019 IBC amendment are with regards to the dealing with the delays which has been happening in the IBC interpretation that has been going on. Now, the first set of amendment that has come is with respect to recording of reasons by the adjudicating authority, which is the NCLT in this matter. Now, the first thing is the admission of the application before the NCLT. Now, Section 7, as we have already read, Section 7 already provides a timeline of 14 days to ascertain, or gives the power to NCLT to ascertain a default and then allow or reject that application. But what that does not give is whether NCLT can record any reasons or not. Now, with this amendment, with this change, this will give NCLT another way to give you a reason whether that admission of the application, why are you admitting, why NCLT is rejecting that application at a stage of admission of the application, so that the timeline can be checked at the admission stage only. But mind you, this application is only for a financial creditor application. This is not for a operational creditor application, because operational creditor application at that in IBC is only dealt with section 10, section 9 of the IBC. Now, moving on, this is with respect to the admission of the application at the first stage.
And just to add to that, on the application stage, while it's supposed to be done within 14 days, on the ground that is not the case. Most anyone who's practicing or seeing how these cases are getting admitted before the NCLT benches will know that in many cases it's been taking several months. So by requiring now the NCLT to actually record the reason why a particular application hasn't been admitted within the 14 days window, it's at least the hope is that the NCLT will be less reluctant to delay admissions indefinitely. So the idea is that if they have to record the reason for delay, at least they wouldn't be doing it habitually as could be seen right now. Of course, we don't know how the effect of this itself remains to be seen, because the courts have said very clearly that this particular 14-day timeline is not mandatory. It is directive. So if the NCLT doesn't follow it, of course, now it has to give a reason which may make it look more closely as to whether it has or hasn't, why it hasn't followed the timeline. But beyond that, there is no consequence. So now I think Sharanya can explain the other area where delays occur in the conduct of the corporate insolvency resolution process itself.
Correct. Now, after the application has been admitted, the main process which governs the insolvency process is the insolvency process of the corporate persons, right? Now, the original text of the code, as we read it gives you a period of 180 days for the corporate insolvency process to be completed. Now, it also provides you an additional 90-day period, making it a 270-day complete period for the whole process to get completed. Now, what we have seen or what have been seen so far is that the 70-day period has been extended to 500 days. And also in the recent cases of SR Steel, also in the SR Steel insolvency case, that has also been extended to 790 days. And the whole point about, the resuscitation of a company, because time is value. Time is crucial for the valuation of the assets. That's the reason the whole IBC code has come to place. That gets defeated with the 270 days and maximum number of extension over and over again. Now, what this 2019 amendment brings it to it is a hard stop date of 330 days. Now, what does hard stop date of 330 days brings it is that it includes all the litigation proceedings which is in relation to this insolvency process, has to be included in the 330 days period of time, in this 330 days period of timeline. So everything has to be completed within 330 days. Now the question arises, what happens if a resolution plan is challenged on the 330th day? Now will that be also included in the 330 day of the period of the resolution? Now again, that will be something we will take into consideration once the NCLT comes in such a case. Now, that is something which we'll see. The 330 days period is something which is given for the proceedings going forward. Now, what happens to the proceedings which are ongoing? Now, the amendment also provides a 90-day period, additional period for those proceedings to be completed. So that is what the IBC Amendment 2019 provides for the dealing with the delays. Now, it's up to NCLT right now how the litigation proceedings, stay proceedings, or any appeal as per Section 61, how they will be dealt with will come into picture.
Yes, and this amendment again was intended to provide certainty to say that 330 days is the hard stop date. If a corporate insolvency resolution process isn't completed by then, regardless of any other litigation or anything else, that the process will have to stop and the debtor goes into liquidation. Whether this will actually happen in practice remains to be seen. Would the NCLT be willing to order a liquidation order if the litigation has come up or a proceeding has been stayed? So it does remain to be seen, but at least one thing that's clearer is that there is an intention to complete within 330 days will be a lot more seriously considered by all the parties.
Yeah, the automatic liquidation part of it is not clear if it is within 330 days or not. That is something which time will tell basically. Moving on to the powers of COC, which I think Aparna would like to take it.
Sure, thanks Sharanya. So on the set of amendments that deals with the Committee of Creditors and their powers and voting, the first amendment that we wanted to mention here relates to how the Committee of Creditors, a vote will be counted where an authorized representative is acting on behalf of various financial creditors. So last year, as many of you may know, and one of the amendments made to the IBC was to explicitly recognize that home buyers would also be considered financial creditors. Of course, the home buyers would be very numerous, and most of them would not individually want to participate in the Committee of Creditors, and that would also make it very unwieldy. So at the same time as home buyers were made financial creditors, there was also an amendment to the IBC which allowed home buyers to participate in the COC through an authorized representative. So that one of the financial creditors would basically be the representative of a whole class of financial creditors, which would, for example, be home buyers. The issue that had come up in practice is how does that authorized representative vote? Does that authorized representative have to take the vote of each of those financial creditors and then vote according to each of their wishes? Which is how initially, and that's how it has been so far until this amendment came about. The issue that came up though was that in some cases, not all the home buyers would cast their vote. And then there was a lot of confusion over how the authorized representative would vote on behalf of the whole class. So this particular amendment now clarifies that an authorized representative would basically have to vote on the basis of how the entire class of creditors that he's representing has voted. So if 51% of the financial creditors who are present and voting in that class vote in favor of a particular decision that the COC wants to take, then that is how the authorized representative would have to vote. So this would simplify voting procedures significantly, particularly in cases where the class size is quite numerous. The one exception to this particular rule relates to withdrawal of applications. So as many of you might know, the IBC permits withdrawal of applications once a matter has been admitted if 90% of the financial creditors consent to the withdrawal. For that purpose alone, the amendment doesn't apply and the authorized representative will have to vote in the manner that each of the financial creditors in that class asked him or her to vote. And I think the reason for this is because the threshold for withdrawal is very high, and so it requires a much larger buy-in from all the financial creditors rather than acting through the authorized representative. So that is the first of the amendments relating to the Committee of Creditors. There are a couple of others, and the next one that I'm going to talk about is probably the most significant and also the most controversial in this set of amendments. And this relates to how proceeds from a resolution plan, the proceeds that the funds that a resolution applicant decides to put in, are to be distributed among the different stakeholders, primarily among the financial creditors and the operational creditors. And I was mentioning earlier how some of these amendments to the IBC have been in particular response to specific judicial decisions. I think this is one case where it's a very obvious response to a particular decision, which is of the National Company Law Appellate Tribunal in the Esser Steel case. And in that case, the NCLAT made a few pronouncements that were quite significant and raised a lot of controversy. First of all, they said that while the Committee of Creditors, it's the function and powers of the Committee of Creditors to decide on the commercial viability of a resolution plan, they did not have the powers to decide on the manner of distribution. So they did not have the powers to say that financial creditors will get a certain percentage of their claim, while operational creditors would get a different percentage. Right? They said that that is a decision that should not be made by the Committee of Creditors, but rather by the resolution applicant who's submitting the plan. And the reason they gave for this was also that the resolution applicant had to certify that the plan was fair and equitable to all stakeholders, which included the manner of distribution being set out. So that was the first of the controversial pronouncements in the NCLAT decision. The second one was that they also said that basically the Committee of Creditors could not have sub-classification in distributing under a resolution plan. The code provides for financial creditors, it provides for operational creditors. As far as the resolution process is concerned, it does not distinguish between secured financial creditors and unsecured financial creditors. And therefore, based on this logic, the NCLAT and Esser Steel said that the resolution plan could not make a distinction between secured and unsecured financial creditors, which many people thought was a very strange result, because the idea of being a secured financial creditor is that you do enjoy some priorities over financial creditors who don't have any security. So as a result, and then the third point in this Esser Steel case, which was also interesting, is that while the Committee of Creditors tried to say that the manner of distribution was also similar to what was provided in Section 53 of the Code, which provides for the waterfall during a liquidation process, the NCLAT here said that Section 53 and the waterfall, which actually allows for priority for secured creditors over unsecured creditors, is not applicable to the corporate insolvency resolution process, that it is applicable only to liquidation. So based on all of this, the NCLAT basically changed how the proceeds from the resolution applicant were to be distributed to the creditors. So initially, under the plan that the Committee of Creditors had approved, most financial creditors were going to get back 99.1% of their claim. And the NCLAT changed it to such a way that all financial creditors was get back 60.5%, and operational creditors were to similarly get back around 60% in many cases. So this decision has actually been appealed by the financial creditors to the Supreme Court. And it looks like the government also thought that this was not the right decision for a number of reasons, because these particular amendments address each of these issues that I mentioned. First of all, the amendment provides that the COC may decide on the manner of distribution as part of its commercial decision in deciding on the feasibility of a resolution plan. It also says that it could provide for priority to secured creditors in accordance with Section 53, to make very clear that the resolution plan could also be based on a similar waterfall as is done in Section 53. And lastly, it says that such a distribution, if done in accordance with Section 53, where priority is given to secured creditors, would be considered fair and equitable to all stakeholders. And this does a couple of things which are quite significant. Firstly, it provides a lot more clarity on how distributions could be made under a resolution plan, because the code is silent on that. Unlike in the fact that a liquidation, there is a very clear waterfall, there is no such priority in the code, and it at least makes very clear that there can be a distinction between secured and unsecured financial creditors. The second thing that it was likely to lead to, and I think that is one of the intentions behind this amendment, particularly in stating that this will be considered fair and equitable to stakeholders, is that the idea behind the code and the idea of a resolution plan itself was that the NCLT and any other judicial adjudicating authority was to have limited ability to scrutinize the resolution plan. The idea is that the contents of the resolution plan are to be based on the commercial assessment of the Committee of Creditors, which is not really something that the judiciary is supposed to scrutinize, unless, of course, it violates a specific law or isn't in accordance with the IBC itself. So now by saying that, this particular distribution under Section 53 and, differentiating between secured and unsecured financial creditors will be considered fair and equitable, that seems to be removing a little bit of the scope for further judicial scrutiny of the resolution plan, which I think a lot of stakeholders had complained about, because in a number of cases, the NCLT would change the resolution plan that had been approved by the COC to, usually in most cases for more equitable treatment of certain creditors, or, in a basis that it felt was more fair. But this now, I think, and this also, one issue was that it did end up giving, in some cases, providing a better distribution to operational creditors, which may have been okay in some circumstances. But more than this, it led to a lot of delays and a lot of litigation around approval of resolution plans because of the ability for greater judicial scrutiny. So with these amendments, and specifically stating that the COC has the flexibility to decide on the distribution, and that the waterfall in Section 53 would be a good way to look at this distribution, I think it may remove some doubts about how a resolution plan and how the distribution needs to be made under a resolution plan. I should add that the operational creditors of Essar Steel have challenged this particular amendment in the Supreme Court. We'll talk about that later. So while the financial creditors have challenged the Essar Steel decision in the Supreme Court, the operational creditors have challenged the constitutionality of this particular amendment. So there is still a lot of movement in this space.
To add to that, I think that order has been stayed by Supreme Court on 22nd July 2019 with respect to the distribution of the operational creditor and the financial creditor. And then the court also has given time to the operational creditor to give their pleas against, reply against all the amendments to the new amendment of 2019, which we'll discuss in a while.
Yes, no, that's very helpful. Thanks, Sharanya. And then the last and the related point on these amendments is that it has also clarified what the distribution that has to be made both to operational creditors and to dissenting financial creditors. And previously, there was a decision of the NCLT which said that there cannot be any discrimination between financial creditors who approve a resolution plan and dissenting financial creditors. Here, it has this amendment makes clear that dissenting creditors must receive at least liquidation value, but it looks based on this that there can be a distinction between assenting and dissenting financial creditors. The code has also, this amendment also clarifies that operational creditors will have to get the higher of their liquidation value and the amount they would have received if the distribution from a resolution plan had been done under Section 53. So these amendments very much make clear that Section 53 and the distribution waterfall is relevant not just for liquidation, as has always previously been the case, but also for the resolution plans themselves. And this again, these amendments too will have retrospective effect to some extent. So if there's any resolution plan that hasn't yet been approved, this would be applicable to that. And also in cases where there's been an appeal of a resolution plan. or any sort of legal proceeding challenging the resolution plan, then this requirement on the minimum payment to operational creditors and dissenting financial creditors would also be applicable. So I think all of these amendments together basically provide more clarity on how distributions are made under resolution plan and what is the minimum amount that operational creditors and dissenting financial creditors must get. Because before this, there were these requirements that previously used to provide that an operational creditor should get at least liquidation value. But there was also a statement that the distribution had to be fair and equitable to all stakeholders. So in many cases, the NCLT interpreted this to be that it was not sufficient that operational creditors got liquidation value. So that is something that may change as a result of these amendments, subject, of course, to the challenges that are before it in the Supreme Court. And the last amendment relating to the COC and its powers, and this is much more of a clarification, is that at any time during the CIRP process, the COC can approve liquidation of the corporate debtor. So if the COC believes that this particular company it's very unlikely that it can be revived, it's not going to receive any interest in terms of bidders or resolution applicants, it does not have to go through the entire 180 days or 330 days of the CIRP. It can decide right away to liquidate. So this was always permitted under the IBC, but has now been explicitly clarified. The last set of amendments around under this IBC Amendment Act now relate to resolution plans, which I'll hand over to Sharanya to talk about.
Now, the last set of amendments are with regard to resolution plan. Now, this set of amendments are more in the form of clarification. Now, first is with respect to the inherent concept of resolution plan. Now, what 2019 amendment has done on the definition of resolution plan is, it has broadened the definition of resolution plan and made it inclusive by including a different restructuring scheme and giving a flexibility to the resolution applicant to include different schemes such as merger, demerger, and other amalgamation scheme into the resolution plan, which can give them other restructuring scheme in the resolution plan as well. Now, another important thing which the IBC amendment has done is, it has made the resolution plan binding on the government bodies. Now, what we have seen is, a lot of times, even though a resolution plan has been approved and it is in process of being enforced and everything, when it is being produced before an authority or a statutory authority, at that point of time, those authority comes with their own claims. And it invariably increases the time period, and again, it increases the litigation processes, thus defeating again the whole object of IBC. With this amendment, what it does is, it clarifies that any resolution plan would be, after approval, would be binding on any statutory authorities, be it a central government, be it a state government, local government, or any authority to whom a statutory due can be levied. Okay, so in that case, I think this would be a very important amendment with respect to the resolution plans being approved and enforced after the approval, and also in response to the claims which can be brought out by the statutory authorities much before the approval is in process. So I think the statutory authorities can be more, I would say, more cautious right now to bring their claims in the time period been provided under the IBC.
Yeah, and just to add to that, I think this amendment is particularly helpful for resolution applicants, because one concern they had previously was very often because the statutory authorities are operational creditors and quite low down in the priority. So they're typically they're not made whole in the as part of the resolution process. But resolution applicants often had a concern that post approval of the resolution plan and after the resolution plan has been implemented and the resolution applicant has taken over the company, could the tax authorities or some other statutory authority come after them at that time, even though their claims were dealt with in the resolution plan? Could they come after them on the basis that they didn't make a claim in the resolution plan, for example? And this, I think, has been clarified here. So, so I think these are the main amendments to the resolution plan and to the IBC Amendment Act. Before going to the liquidation regulations, I thought I have a few questions here which I'll try to answer. The first one is from Rohitesh, and he says, with the distribution rights now conferred on the COC, would it enable COC to distinguish between two classes of secured creditors as happened in the case of SSD? I think this is talking about a good question, and it's talking about whether even among secured creditors there could be first lien holders and second lien holders or different types of security interest. Would this power allow the COC to distinguish among these subcategories? And I think we can read it broadly to say yes, because the way the amendment is drafted, it says that the COC has the power to to determine the manner of distribution, including giving priority to secured creditors. So given that, it is quite broad for the COC to be able to do this, but that remains to be seen whether the courts will actually allow for these subclassifications. And one thing that would be quite important here is that the COC has a very clear rationale for why it's making these distinctions. Because if it doesn't, the idea is that even here that similarly situated creditors will have to be treated similarly in a resolution plan. But there is scope for classification among these categories of creditors. The other question, again from Rohitesh, is that he says, as per section 53, the assets of the subsidiary company cannot become the liquidation estate. Now, since section 53 is applicable, would it not affect the group insolvency proceeding, which has gained sanctity in light of the Videocon case? Okay, so I think this takes us to a slightly different issue. But you are right that the assets of the subsidiary company, the subsidiary is a separate legal entity, and therefore its assets are not part of the corporate debtor's liquidation estate. I don't think this, just because section 53 has become part of the resolution process that it applies, I don't think this directly affects the resolution process in terms of where the subsidiary is concerned. In terms of group insolvency proceedings, I think this is still an issue that's being considered. There's a committee that's looking into it and looking into whether there should be a separate set of rules for dealing with the insolvency of group enterprises. And we are right, particularly in light of the Videocon case, where there are a number of companies and they're all interrelated, but they're all separate legal entities. So the insolvency proceedings going on in parallel wouldn't really make sense. But that is a slightly different issue from what we are considering today, but I hope that answered part of your question. And the other question I have is, what is the binding value of the stay that FE gave in light of section 64.2, which bars any kind of injunction? So I think that's right, but since they have appealed it to the NCL, to the Supreme Court, and the Supreme Court has stayed the implementation of the resolution plan, I think that it would be, I think based on the powers of the Supreme Court, it would be binding. I do take your point though on section 64.2, but I think appeals are allowed to the Supreme Court in any case. So based on that, it would be binding. The next question I have from Karthikeyan is, if an RP requires a government authority to make certain payments under a contract, is the authority bound to comply. What is the court of appeal for the authority? So this is a slightly different question in the sense that the RP, of course, takes over the company, and I think this relates to the conduct and how the RP manages the company during the CIRP process. And in this process, of course, there may be government authorities that have contracts with the corporate debtor. And ideally, because the RP is to manage the corporate debtor as a going concern, ideally the government authority would be honoring its commitments to make payments under these contracts. The RP can definitely ask for that, and there are rules around certain essential services cannot be suspended. But beyond that, if the government authority terminates a contract, I think there have been a number of cases on this. There isn't too much that the RP can do to compel the party to continue the contract, unless it is for an essential service. So that is the general idea here. What is the court of appeal for the authority? I mean, if the RP is doing this through the IBC, then the authority would have to challenge this before the NCLT. Unless, of course, if it's a very specific authority and there's a specific act it can go under, then that is something they can think about. So it will depend very much on the facts here. The other question Karthikeyan has is the 90% approval refer to the number of financial creditors present and voting? No, it doesn't. It actually represents the 90% in value of the financial creditors, of the claims. So financial creditors holding 90% of the claims of all financial creditors put together will have to approve in order for the application to be withdrawn. So thank you very much for those questions. That was quite useful, and it helped me also get some interaction going. So then after this, we'll just briefly discuss. I think we'd also mentioned here that
I think we have
one more question. Okay, let's go to that as well. The consent of the applicant required for withdrawal, absolutely. And it doesn't say that explicitly, but the procedure for withdrawal is that the applicant has to make the application to withdraw. So even if, for example, an operational creditor has filed an application and all the financial creditors consent to withdraw the application after it's admitted, the operational creditor would also have to consent, because it's applicant which will have to make the motion, the application to withdraw in the first place. Okay, thank you for those questions. So just moving on to the liquidation regulations. Oh, sorry, before that, we can just, as I mentioned earlier, some of these amendments are currently being challenged in the Supreme Court. Specifically, the operational creditors in the SR Steel case have challenged the amendment, saying that it's discriminatory over operational creditors, and operational creditors cannot be treated in the same way in both liquidation and a resolution. Because the idea is in a resolution that the company is going to continue, and operational creditors might be providing services to the company as well. Whereas in liquidation, there's a limited amount of assets. And so their contention is that the waterfall in Section 53 cannot be made to apply to resolution plans as well. So it remains to be seen how the Supreme Court will deal with this issue. There have been other constitutional challenges to the IBC, and one especially in the Swiss Ribbons case, where the classification between operational creditors and financial creditors was challenged. In that case, the Supreme Court upheld the classification, saying there was a reasonable basis to differentiate between operational and financial creditors. We'll have to see whether these amendments and the powers they give to the COC are upheld, or whether it's considered too discriminatory to operational creditors. More recently, very recently, the Supreme Court also upheld the home buyers being financial creditors under the IBC. So far, most of the challenges to the code have been upheld by and large, but it remains to be seen what happens here. think it's now the court has sought a response from the government and listed it for September 17th. So this is a space we need to continue to watch. Okay, so now moving to the liquidation process amendment regulations, and I will go over this slightly more quickly because some of these are fairly technical, but there were generally a lot of issues with how the liquidation process was run, and there was a committee constituted to look into these questions, and a lot of these amendments are as a result of that, and most of them are to the process itself. One fundamental difference between the liquidation process and the resolution process is the role of the resolution professional versus the role of the liquidator. So while the resolution professional is basically a facilitator in the process, but doesn't actually have the authority to make decisions, the decision-making power is with the COC, that's not the case in the liquidation. So it's the liquidator that has the power to decide what to do with the asset, how best to get the maximum value for the assets. And therefore, based on this distinction, some financial creditors especially felt that there wasn't a lot of control or visibility they had over the liquidation process. And one of the changes that has been made as a result of this is the constitution of a stakeholders committee during liquidation, which is to comprise of some financial creditors, operational creditors, as well as in some cases also shareholders. Each of these different classes are to have a representative. And the stakeholders committee, the liquidator, is to keep the stakeholders committee updated on the status of the liquidation and also address any issues or concerns raised by the stakeholders committee. The other related amendments also relate to how there has generally been a bias in the code in favor of resolution over liquidation, which especially in the implementation. And so some of these amendments also talk about this concept where even if a liquidation order has been passed, that doesn't necessarily mean that the company has to be liquidated and its assets can be sold separately. So in a previous amendment, there was a concept of a going concern liquidation that was introduced. And similarly, even after a liquidation order has been passed, there could be a scheme that's done under the Companies Act. So these are just a quick snapshot of the amendments. The first amendment is fairly technical, so I won't spend too much time on it, but it allows the financial creditors to make contributions to the liquidation costs during the process. Because liquidators were finding it quite difficult to fund the liquidation, and therefore this amendment allows the liquidator to actually call upon the financial creditors to contribute to the liquidation costs in proportion to their claims. Then, and then the other, and this of course is a change that's kind of important in terms of being able to fund the liquidation process, but it's not very clear how it will actually work in practice, how these funds will be called for. They're to be put in an escrow account, and at the end of the liquidation, they're actually supposed to be returned to the financial creditors with interest. So how this whole mechanism will work is something that remains to be seen. The next amendment is relates to the time period for compromise or arrangement, and this relates to how under the liquidation regulations allow for a compromise to be made under Section 230 of the Companies Act. So that is one of the ways in which the company can be maintained as a going concern even after a liquidation order is passed. And the only clarification here is that this will have to be done within 90 days of the liquidation order being passed. So there's a little bit of a balancing act being done here. At one level, they want to provide opportunities even after the liquidation order has been passed for the debtor to be sold as a going concern rather than stripped off all its assets and liquidated. At the same time, they realize that this process cannot continue forever, which is why they've put in a sort of timeline for this. But as Sharanya will explain, there is a little bit of a gray area here.
Because if you see, because what the regulation 2B talks about, the amended regulation, it says that the the compromise and the arrangement has to be completed within 90 days. Now, as we know, as per section 230 of the Companies Act, the process of compromise and arrangement itself takes 6 to 9 months for completed, because you need shareholders and other stakeholders approval. Then the same needs to be approved by the NCLT, and there is a huge process which is given under the Companies Act, which has to be followed. Now, it is quite confusing as to what would the term completion would mean. Would it mean that we would be done with only the formulation of the scheme of arrangement and obtaining the consent from the stakeholders? Will that mean the completion within 90 days? Or otherwise, we don't think the whole restructuring of the scheme of arrangement can be completed in 90 days. So that is something which we would be watching it, as NCLT would be dealing with as it comes.
Yeah, I mean, I think probably it means if a scheme or compromise has been agreed to, rather than the entire process completed, because that cannot happen in 90 days, but it's not very clear.
Now, moving on, there is another clarification which liquidation regulations has brought in. Now, as we see in this, there is two regulations now. Both resolution CRT regulations have is there also you need to submit claims. You need to submit claims as proof for your claims. Now, similarly, in liquidation process regulation, also you need to submit those claims. Now, often there is always repetition or duplication of those claims. Now, what this amendment has done is to prevent those duplication and repetition of claims. Now, what only a person has to do is he can only submit and update those claims if it has already been submitted as per the CIRP regulations. So that is something which is a helpful amendment in this process.
And similarly, another amendment, which is again more process related, relates to what a secured creditor needs to do during the liquidation process. So a secured creditor needs to has two options. The secured creditor can either decide that it will stay outside the liquidation process and enforce its security interests separately, or alternatively that it will include its secured asset as part of the liquidation estate, so that the cost that the assets that the secured creditor will realize will be based on the entire pool of assets. So it can choose to either stay outside or within the liquidation process. The practical issue that was coming up for liquidators was that secured creditors weren't actually informing the liquidator once the liquidation order was passed as to which option they were planning to take, which meant that the liquidator would basically not be able to do very much with the secured assets, which would of course lead to inefficiencies as well as erosion of value of those secured assets. So this amendment basically requires the secured creditor to inform the liquidator of which option it is going to choose. And if it doesn't do so within 30 days, the assets will be presumed to be part of the liquidation estate. So it requires secured creditors to specifically take this action to inform the liquidator. The second part of this amendment is more of a clarification that basically if the secured creditor chooses to realize its security interest, because under section 53, the secured creditor is pari passu with workman dues, any amount that's due to the secured creditor, it will have to contribute a proportionate amount to workman dues, similar to what it would do if it chose to be part of the liquidation. The next point here, another amendment which I spoke about before, is about the constitution of the stakeholders consultation committee. And the idea here is to ensure that there is a little more accountability and visibility about what the liquidator is doing. And there are And also the stakeholders committee, while it's comprised of a number of different stakeholders, unlike the COC that is comprised only of financial creditors, it is secured financial creditors who have the maximum representation on this stakeholders committee. This, I think, is generally a welcome step, so there is more transparency in the liquidation process. But we'll have to wait and see how this actually works in practice. The final, there's just one. Yeah, do you want to go over this last
Yes.
change?
So this is more, so this amendment is more like a clarification which came in the liquidation regulations as well. Now, liquidation regulation had previously allowed liquidation by going concern, sale by going concern. Now, what this amendment does is, it just provides the sale by going concern to be taken at a higher pedestal than any other sale. And additionally, what it does is it provides a time period of 90 days that the sale by going concern needs to be completed. Additionally, there is another point that after the expiry of 90 days, there can't be another process taken by, another attempt taken by to sell the assets by going concern. So you have to take any other process of selling the assets of the corporate debtor. So that is the amendment which has been brought out as for the regulation 32A, which is, I think, giving more chances to other forms of selling your assets.
Yeah, so explicitly made the clarification, first of all, that even in a liquidation, the business can be sold as a going concern. But if they choose this route, they do have to decide in 90 days, because the idea is they've already had 270, now 330 days to figure out a going concern, way of keeping the corporate debtor as a going concern to a resolution. So while they could continue to do that in the liquidation process, they couldn't spend too much more time on that, because that might seem futile. So at some point they will have to decide that, okay, this business can't be sold as a going concern, would have to go into liquidation. But this process has been extended to allow for them to continue to look at it as a going concern in liquidation also. The last set of amendments, which we won't really go over, is that there are new timelines now, such that the entire process actually has to be completed. It used to have to be completed within 2 years. Now it has to be completed within a year. So it's the timeline has been compressed substantially, and there was a concern that otherwise liquidation was taking much longer. Because while the corporate insolvency resolution process has a lot of visibility over what's going on, once a liquidation order has been passed, and this is something true of the prior regime as well, it would often take several years and kind of disappear from everyone's horizon. So I think they've tried to keep it at 1 year to shorten the process of liquidation even further. So I think that brings us to the end of all the amendments and discussions. We will consider questions. So if you do have any, please feel free to type them in. I've got another question from Karthikeyan here, which I think he'd asked earlier as well. Sorry about that. The question is, since the board is suspended once the resolution process commences, who is responsible for the routine operations now that the management does not have ready access to the funds to expend on the operations? Who is liable for any non-compliances during this period? A very good question. And the way it works is that during the resolution process, the board is suspended and the resolution professional takes over the company. The resolution professional is allowed decisions around financing have to be made by the COC. And the resolution professional is allowed to obtain interim finance for ensuring that the debtor can be maintained as a going concern during the resolution period. That said, in practice, this is pretty difficult because it's not very easy for an individual to come and take over a business. But there are certain requirements under the code that help that, in the sense that the code requires the management of the corporate debtor to cooperate with the resolution professional, provide him access to the accounts and information. But that said, it is difficult, and typically what happens is the resolution professional does end up hiring professionals to manage the company. The other question is, but isn't so Shalini has asked, but aren't all compliances under 230 effectively taken care of when the claims are filed and the exercise run by the liquidator? So I think that's what is intended to happen, that during the liquidation, they're supposed to do a scheme or compromise under section 230 in lieu of the liquidation proceeding. That said, the steps, there are quite a lot of steps there under the Companies Act. So our only point was that it probably can't be completed within a 90-day timeline. So that would be quite difficult to do. Though, of course, they can decide on the terms of the scheme of compromise, but to complete all the steps of the scheme of compromise within 90 days would be quite difficult. Mudit Jain has asked, what is the effect of imposing various timelines when we have seen that there have been numerous instances of non-compliance in past as well? What shall be the repercussions? That's a great question, but I wish I had an answer to it because I think that is something we've seen time and again in the IBC and in other laws as well. And I think one reason it's very difficult to enforce these timelines is because there are lots of factors outside one's control, including the caseload and how quickly the NCLTs and tribunals are able to move on these cases. And also, we can't stop people from litigating. So every time there is a resolution plan is approved, there is a lot of litigation around it, and there can be a challenge to the resolution plan that of course delays things. I think the way of trying to impose these timelines is if there are clear consequences. And I think one example of this is the timeline for admission. While it says 14 days, in reality, there cannot be a consequence if the application is not admitted within 14 days, because really what could the consequence be? You can't penalize the NCLT or any of the parties for that. You can't dismiss the case because that would be, against the interests of the applicant. On the other hand, there is a very clear consequence if the CIRP isn't completed in 30 days, which is liquidation. But that again is such a drastic consequence that sometimes the tribunals aren't willing to implement it just on day 330 because that happened. So it is a very good question. The hope is that by putting timelines in place, even if they are not adhered to the letter, they at least make all the parties a little more serious about following the timelines and, even not within that particular timeline, within a reasonable time frame. Check. Yeah, so I think that is an important point that my colleague here just mentioned, that basically the NCLT, they do monitor how quickly the NCLT is admitting cases or disposing cases. And I think, for example, this change where they actually have to give a reason for delays will give a little more accountability to the NCLTs and to the process itself. Will it stop all delays entirely? No, but I think it's probably a step in that direction. Nupur has asked a question. Since home buyers are treated as financial creditors now, would they be secured or unsecured creditors? The code is silent on this. It's a very good question, but it'll really depend on a case-by-case basis. I think we have a few more questions here. Okay, some of them are done, I think. Sorry, just give me a minute. Okay. As per the new, Rohit has asked, as For the new amendment, a period of 330 days has been prescribed to complete the resolution process. Does it mean to include the full implementation of the resolution plan? No. It just means 330 days that the COC has to approve the resolution plan within 330 days. After that, the NCLT has to approve the resolution plan. And after approval, there is a time period of a year that is given to implement the resolution plan. So the implementation takes place later. The 330 days is for the resolution plan to be agreed to and approved by the COC. Rama Meenakshi has asked, if a statutory authority has not raised any claim till admission of the case in NCLT, can they include their case in the RP? I think, if I understand this question correctly, I think yes, the answer is yes, they can. The idea is that in the RP, after admission is the time during which all the stakeholders, all the creditors, including statutory authorities, can raise claims to the resolution profession. What has been happening in some cases is that the statutory authorities don't raise their claims to the resolution profession, or they do it much later. Very often the resolution professional will put in a deadline by which claims are to be submitted, and they often don't adhere to that deadline in practice, maybe because, I mean, depending on the statutory authority, that's not something they've been following, or that they think they may not need to make a claim because they are a statutory authority. They do have to make a claim in order for it to be considered by the RP.
I think Nupur has another question. Her question is, what happens if CCI does not give approval for a merger as part of the resolution plan? Is it all reversed, which would be waste of 330 days?
Yeah, so on this point, actually, CCI, while most approvals have to be taken that are required for implementation of the resolution plan have to be taken after the resolution plan has been approved, CCI approval alone has to be taken before that. And I think that's exactly for the reason you identify, Nupur, because if CCI approval is not obtained after all the effort of agreeing a resolution plan, it would really be a waste.
So any scheme between a COC that approves and not approval for a merger and a amalgamation?
Yeah, so yes. So basically, under a resolution plan, there's also a clarification that says that if there's any sort of resolution plan that would normally, because for example, a merger or a scheme that would typically require shareholder approval, it won't be required when it's done pursuant to the IBC. Because in that case, the COC approval and the processes are sufficient. Okay, I think that is the end of the questions that I see. I hope you all found this informative, and I really enjoyed speaking to all of you, and thanks very much for your questions. They were really helpful, I think, and added to a lot of points.
Sorry, there's one last minute question.
Okay, sure, we can consider
I think
well.
Mudit has come with Shashidhar's question. Okay, his question is, as has been laid in case Shashidhar versus Indian Overseas Bank by Supreme Court, that adjudicatory authorities can't question the commercial wisdom of COC. Are there still ways or matters in which adjudicatory authorities do have a say apart from a clear violation of the IBC provisions?
Yes, so this is something that I think was what the amendments are really intended to address. They have been saying this, that, you know, the adjudicating authority can't question the commercial wisdom, but so far the adjudicating authorities have found ways of questioning or amending the resolution plan. I think by making clear that the manner of distribution is something that's within the commercial wisdom of the COC to decide, as long as it otherwise complies with the provisions of the IBC, I think it will be harder for the adjudicating authorities to question the commercial wisdom of the COC or look beyond whether the resolution plan actually complies with the requirements of the IBC. That said, again, we'll have to wait and see how this is actually done and whether there are more innovative, that the adjudicating authorities find more innovative ways of, trying to make amendments or go beyond what is specifically required of them under the IBC in terms of a review of a resolution plan.
Because whenever this point has come to question the commercial wisdom of COC, it has always been that COC comprises of all the financial creditors, so they know the finances of the company. So I think, again, we would have to see what NCLT or any other forums would be deciding on this point.
Okay, I think with that we will stop. We've also just reached the end of our session today, but thank you so much for joining in. And as you can all see, the IBC is a very dynamic law. It's constantly evolving. So we will hold more webinars and updates on this topic in the future, and we will let you know as and when we do so. Thank you again for attending.
Thank you, everyone. I think we stop recording.